On July 1st, 2026, less than 3 weeks from now, it becomes illegal to buy, sell, or transfer a semi-automatic rifle in the Commonwealth of Virginia. Not in California, not in New York, in Virginia, the state where the Bill of Rights was written. The state where James Madison drafted the Second Amendment. The state where Patrick Henry stood up in a Richmond church in 1775 and said, "Give me liberty or give me death." That state just banned your rifle. Senate Bill 749 was signed into law by Governor Abigail Spanberger earlier this year. It defines semi-automatic center-fire rifles and pistols with certain features as assault firearms and prohibits their sale and transfer starting July 1st. Magazines capable of holding more than 15 rounds are also banned. Violators face up to 12 months in jail. If you legally own one of these firearms before July 1st, you can keep it. The law grandfathers existing owners. But the moment that date flips, the gun store down the street in Richmond, in Roanoke, in Virginia Beach, they cannot sell you one, not legally, not anymore. And here's the question that matters beyond Virginia's borders. If it happened here, in the birthplace of American liberty, where exactly is it safe? To understand how Virginia got here, you need to go back to November 2025. Virginia held its gubernatorial election, and Democrat Abigail Spanberger, backed heavily by Michael Bloomberg's gun control network, defeated the Republican candidate and took the governor's mansion. The shift was decisive. Virginia's General Assembly was already Democrat-controlled. With a governor who had explicitly promised gun control legislation during her campaign, the path was clear. In March 2026, the legislature wrapped up its session having passed more than 15 pieces of gun-related legislation in 60 days. The crown jewel was SB 749, the assault weapons ban. It passed the Senate 21-19 on a straight party line vote. Not a single Republican voted for it. Not a single Democrat voted against it. Pure partisan mathematics, applied to the Second Amendment rights of 5 million Virginia gun owners. The speed of it stunned even veteran gun rights advocates. Virginia had tried this before. In 2020, under Governor Ralph Northam, a similar assault weapons ban was introduced and then quietly shelved when moderate Democrats got cold feet. The votes weren't there. Gun rights organizations celebrated what they called a victory. 5 years later, the votes were there. And this time, nobody got cold feet. The lesson from those 5 years is one that every gun owner in every state should be paying close attention to. Electoral politics and gun rights are directly connected in a way that no amount of legal challenge or advocacy can fully substitute for. Virginia changed governors. Virginia changed its gun laws. That sequence is not a coincidence. What the law actually bans. The language of SB 749 is broad enough to capture most modern sporting rifles currently on the market. The law defines an assault firearm as any semi-automatic center-fire rifle or pistol that accepts a detachable magazine and has one or more of a list of specific features, things like a pistol grip, a folding or telescoping stock, a thumbhole stock, or a grenade launcher mount. By that definition, the AR-15, the most popular rifle in America, with an estimated 20 million in civilian ownership nationwide, is an assault firearm under Virginia law. So are many other commonly owned rifles that millions of Americans use for hunting, sport shooting, and home defense. Magazines capable of holding more than 15 rounds are also banned from sale or transfer. Given that the standard magazine for many popular rifles holds 30 rounds, this provision alone affects a significant portion of currently available ammunition feeding devices. The grandfathering provision is real, but limited. If you owned one of these firearms before July 1st, 2026, you can keep it, you can use it, you can take it to the range. What you cannot do after that date is sell it to another Virginia resident, transfer it, or pass it down to your son in Virginia when you die. The rifle you own becomes, in practical terms, a dead-end asset. It exists in your hands and nowhere else in the legal Virginia market. That's not a ban in the confiscation sense, but it is the slow extinction of a class of firearms from the Virginia civilian market, and everyone who understands how these laws work knows exactly what comes next. Here's the part of this story that isn't getting enough attention nationally, and it matters. 58 Virginia counties and cities have announced they will not prosecute residents solely for violations of the new assault weapons law. That's not a small number. That's a significant portion of Virginia's political geography, mostly rural counties in western and southern Virginia, where gun ownership is culturally embedded and the new law is viewed as a direct attack on a way of life. The Pulaski County Commonwealth's attorney stated publicly that he will not criminalize behavior that was legal on June 30th, simply because a calendar date changed. Warren County's prosecutor said the same. Dozens more followed. This creates a bizarre two-Virginia reality. In Northern Virginia and the Richmond suburbs, where the political weight that elected Spanberger is concentrated, the law will likely be enforced. In rural Virginia, where sheriffs and prosecutors are elected by communities that overwhelmingly oppose the law, enforcement may be effectively non-existent. That patchwork is not a stable situation. It is a legal and political tension that will eventually force a resolution, either through the courts, through future elections, or through federal intervention. Watch this space. Gun rights organizations have filed legal challenges. The NRA, Gun Owners of America, and the Virginia Citizens Defense League are all involved in litigation challenging the law on Second Amendment grounds. The legal argument mirrors the Maryland Glock ban case, that the firearms targeted by this law are in common use for lawful purposes and therefore constitutionally protected under the Heller standard. The outcome of those cases is genuinely uncertain. Courts have split on assault weapons bans in different circuits. Some have upheld them, some have struck them down. The Supreme Court has declined to take up the issue directly in the years since Heller, leaving a patchwork of circuit court decisions that vary significantly by geography. The bigger picture. Virginia is the 9th state to pass some form of assault weapons ban or restriction. California did it first, decades ago. Illinois, New York, Massachusetts, Connecticut, New Jersey, Hawaii, and Maryland have versions of similar laws. Now Virginia. The pattern matters. Each new state that passes one of these laws provides a legal precedent, a political template, and a signal to other states with similar legislative makeups that the move is achievable. The gun control organizations funding these campaigns, Bloomberg's Everytown for Gun Safety being the most prominent, are explicitly running a state-by-state strategy. They have said so publicly. They learned from the difficulties of passing federal legislation and shifted their resources to state capitals where they could achieve legislative majorities more easily. The firearms industry and gun rights organizations are running a parallel counter-strategy, funding legal challenges, supporting pro-Second Amendment candidates, and building the kind of legal arguments that they hope will eventually force a definitive Supreme Court ruling that settles the constitutional question once and for all. That ruling hasn't come yet, and until it does, the legislative fights will continue, state by state, election by election. For the Virginia gun owner standing in a gun store on June 30th, 2026, buying the rifle he wants before the clock runs out, this is not an abstract constitutional debate. It is a deadline. It is the last legal opportunity to make a purchase that will be illegal tomorrow. Thousands of Virginians have been doing exactly that. Dealers across the state have reported surges in sales of the firearms targeted by the new law. The grandfathering provision, ironically, created a buying rush that has put more of these rifles into Virginia homes in the weeks before the ban than would have been sold in a normal 6-month period. The law designed to reduce the number of these firearms in Virginia may have temporarily increased it. That's the particular irony of firearm legislation with grandfathering provisions, and it has played out the same way every time one of these laws has passed anywhere in the country. What happens next? 3 things are certain. The legal challenges will take years to resolve. Courts move slowly. Appeals take longer. The Virginia law will be in effect, enforced in some jurisdictions and ignored in others, for years before any definitive judicial outcome. Other states are watching. Florida, Texas, and other states with strong gun rights traditions will use Virginia as a warning, a fundraising and organizing tool for pro-Second Amendment political movements. States with legislative makeup similar to Virginia's will use it as a roadmap. And the question that opened this video, if it happened in Virginia, where is it safe, will keep getting asked. The answer, increasingly, depends less on constitutional principles and more on who won the last governor's race in your state. That's the reality of American gun rights in 2026. Not settled law, not a permanent guarantee. A political contest fought election by election, state by state, with the Bill of Rights as the prize. If you're a Virginia gun owner, drop a comment below and tell me how you're handling this. And if you're watching from another state, tell me if you think this is coming for you next. This is the most important Second Amendment story in the country right now, and I'll be covering every development as it happens. Subscribe and ring the bell so you don't miss the updates. See you in the next one.